Good afternoon, everybody, and welcome to this afternoon's webinar, looking financially focused Mauritius. Thank you so much to everybody that's attending today and that's joining us. Just before we get going, a little bit of house rules or some information. If you look at your screen, you'll see at the bottom, there is a little box that says chat. That enables you to add some questions. If there's any particular information that you're needing or looking for, you can add that to the chat box and we will go through that towards the end of the webinar. Second to that, we're going to be running through a few polls. These polls will come up on your screen. You'll be able to, if you have a moment, just answer the poll, and that information will be shared with you towards the end of the webinar. We are recording this event so that we can play it back and upload it to the Estate Living website so that you'll be able to view it at your leisure at a later time. But without further ado, let us have a look at our esteemed panel that's with us today. So financially focused and tax, I'm not sure whether how excited we're going to get about that, but I think it's a very, very important part of any sort of immigration or investment into Mauritius. So we've brought together today an exciting panel, and they will introduce themselves. So I'm going to run down the list. First and foremost, I'd like to introduce Ian Chambers. Ian, would you like to tell us a little bit about yourself and your expertise?
Yeah, sure. Thanks, Louise. Thanks for hosting the webinar. By my accent, you understand I'm South African. I've immigrated from South Africa in 2008, where I previously was in a partner of an audit firm and a law firm in South Africa, specifically engaged in income tax and exchange control. I did my national service at Inland Revenue in South Africa in the legal department. And I continue to service my clients from South Africa, in South Africa, from Mauritius, understanding both the Mauritian income tax legislation and the associated legislation, as well as the South African income tax legislation, which investors must be particularly careful of when investing outside South Africa if they are South African tax residents.
Thank you, Ian. So Ian's going to be covering the tax consideration part of today's program. Tarura from Jury Stacks is going to be looking at the setting up of a trust. Taruna, if you would mind introducing yourself.
Hello everyone, I'm Taruna, so I'm the Director of Legal and Compliance of Jury Stacks Group, which is a company based in Mauritius, and we are here to assist people who would be interested to come live in Mauritius or to do business here. In just a few words, I am very happy to answer to any of your questions you may have at the end of the presentation.
Thank you. So a big part of moving across is looking at setting up a bank account and the financial requirements, and then of course also looking to see whether it's possible to finance any immovable property purchase. So we are very excited to have ABC Bank with us. And Diane, if you could introduce yourself.
Thank you, Louise. Good afternoon, everyone. I'm Diana Badal from ABC Banking. So I am private banker at ABC since 2 years, but with an overall banking experience of 12 years. So we are here, we are happy to help you and guide you in your acquisition project in Mauritius.
Thank you so much. So a big part of what's happening in Mauritius is off-plan purchases. And what's quite interesting about off-plan purchases is they are structured a little bit different to how they are in South Africa. So we've got two exciting things happening here. One is we're going to discuss the breakdown of off-plan purchases, but we're going to look at it through a brand new development that hasn't actually even launched. They're discussing it for the very first time here with us at Estate Living, and we are so very proud of that. But we're going to do it slightly different. The developer of this particular development has a first language is French, Fabrice. And so we have brought along Olivia, who's part of our Estate Living team, and she is going to act as a bit of a translator as we go along. So Fabrice, if you would like to introduce yourself, and maybe Olivia as well.
Hello, my name is Fabrice Suissa. I am from France with my accent. I'm working 25 years in France, in Paris and all the area around about the project development. I'm working with a big promoter in France, Kaufman Boat, Cogedim, Vinci, Bouygues, and etc. And I really want to change my life, and I live now in Mauritius. I am in love, and I am in Mauritius. And during more than 1 year, I study all the market for find land for development and for many things. And I find a lovely land with a partner, French partners, is promoter too, developer. And we start a new project with penthouse, apartment, and house near to the beach and near to the school and everything. And Olivia, she explained you better than me in English all the advantage about this program.
Thank you so much, Fabrice. Olivia, seeing that you're representing Estate Living Mauritius and the new project at the same time, perhaps you could introduce yourself and let us hear a little bit about what you're doing on that side.
Yeah, good afternoon, everyone. I'm very happy to be here today doing a bit of translation, but I'm actually going to introduce that fantastic new project. So I'm the ambassador for Estate Living in Mauritius. And I've been very happy to work alongside Louise, obviously yourself, and Jamie Lee, and putting together this amazing Mauritius consortium. So we look forward to all your questions, and I'll see you later for the introduction of North Island's view.
Fantastic. Thank you so much, Olivia, and thanks for joining us today. So let us get going. This webinar is scheduled for an hour, so it's a relatively big topic, so we're going to hit it. Ian, let's start us off with the exciting tax considerations. Over to you, Ian.
Thanks, Louise. I think that consideration when investing in property in Mauritius, you must be aware of the South African tax considerations. South Africa's got a residence-based taxation system, and that means that if you are tax resident in South Africa, you're subject to tax on your worldwide income and your worldwide capital gains. And South Africa has got a very, very complicated income tax. It's got very, very complicated income tax legislation. So there are many, many pitfalls for the unwary in structuring their affairs. You know, Mauritius has got a personal tax rate and a corporate tax rate of 15%. So should you be purchasing a rural property in Mauritius and not have any tax shield against that property rental income, you'll pay 15% in Mauritius. But if you're on the top tax rate in South Africa, 45%, you end up paying the difference of 30% as an additional tax liability in South Africa. And then in addition to the income taxes and capital gains tax that exist in South Africa, there's also donations tax. Donations tax when gifts are made, levied at the rate of 20%, and then to capital, there's death duties or estate duty, which is levied at 20% on the death of a taxpayer. Sorry, could you please move to slide 3 of the presentation?
Are you with us, Ian?
It's not on there, but if it's on, that's great. So, what's the final issue with South African taxes? Nothing final but debt and taxes. And if you, upon your death, you are deemed to dispose of all your assets and immediately reacquire them at their market value. That triggers a capital gains tax liability. And then on the value of your estate after capital gains tax liability is taken into account, you are subject to estate duty. Then let's start moving in towards the manners in which you can hold immovable property in Mauritius. Obviously, you can hold in your personal capacity, and by holding that property in the personal capacity, I've raised the issue of the so-called top-up tax that you would have in South Africa by virtue of the differential between the Mauritian tax rate and the South African tax rate. Then there's the possibility of holdings in the trust. Taruna will explore what a trust is in Mauritius and how it's managed and the concept thereof. You can hold it in a company, or you can hold it in a society, which for all intents and purposes is a partnership from a South African legal point of view. Now, obviously, to avoid South African tax totally would be to pack up and leave and tax emigrate from South Africa. The effect of the tax immigration from South Africa is to pay effectively exit tax, where you deem to dispose of all your assets and immediately reacquire them. And then the difference between the original base cost of those assets and the market value of those assets at the time of immigration will give rise to a capital gain, and that's you'll pay capital gains tax on that on your emigrating from a tax point of view of South Africa. So it's a one-off tax, and the advantage or the benefits of emigrating from a tax point of view in South Africa is that from that day forward, you're then only subject to tax on income from a South African source or from income earned from a deemed source in South Africa. And in addition, you're not subject to any capital gains tax. And obviously, by taking up residency in a different part of the world, you won't be subject to estate duty in South Africa. Just to compare that from a Mauritian tax point of view, it doesn't cost anything to die in Mauritius. We don't have death date duties or estate duty. We don't have any donations tax, and we don't have any dividends tax that's on any distribution made by a company to its shareholders, as you do in South Africa. But in order to emigrate from South Africa, you physically must leave South Africa. And to remain tax emigrated from South Africa, you need to ensure that you don't fail something called the physical presence test. And effectively, you need to ensure that you're absent from South Africa on average for more than 6 months per year or every year. And it's done over a rolling average of 5 years. It's a technical calculation, but I merely mentioned that those participants are aware of it. The whole issue of obviously emigrating from a South African point of view doesn't happen immediately, and it takes time to wrap up one's affairs in South Africa. So there may well be a point in time where you wish to acquire the property, not sure whether you are going to emigrate, but you wish to ensure that that asset that you have acquired is not going to be subject to estate duty in South Africa, not be subject to income tax in South Africa, not be subject to capital gains tax in South Africa, could you ultimately dispose of that assets in some point in time. And I mentioned the issue of capital gains tax. So the two preferred options, or certainly the preferred option of acquiring a property in Mauritius for South African tax residents is to ensure that the ultimate holder of that property is a trust or a Mauritian trust. But South Africa has got extensive anti-avoidance legislation that deems the income earned by the trust to be taxable in the hands of the donor. For instance, if you loan the money to the trust, there is a deemed minimum interest that needs to be raised on that loan, and that interest would attract income tax in South Africa. If you merely donate the money to the trust the quantum of that donation will attract donations tax, and over and above that, because of anti-avoidance provision, any income earned by that trust will also be taxed in South Africa. So there's a definitive steps that you need to go by, and a planning opportunity, a planning process that needs to be embarked upon to ensure that you don't fall foul of the South African anti-avoidance legislation when establishing the trust. And I'm merely mentioning the planning process, and we're not going to go through the actual fundamentals here, because I think it's far too involved for the seminar, where we're going to address other items, but merely be aware that there are the anti-avoidance provisions in the income tax, and we're obviously welcome to address those issues or provide the bespoke finance or the bespoke structure in setting up those structures. The other option is also to hold the property in a company in Mauritius. Again, we sit with anti-avoidance legislation in South Africa, is that where a South African tax resident or residents own more than 50% of the equity in the foreign company, that foreign company is considered to be a controlled foreign company for South African tax purposes. And the effect of that is that the net profits or the taxable income made by that foreign company, as determined in terms of the South African Income Tax Act, is merely attributed to the South African tax resident. So again, for the uninformed, merely put into a company without the associated structure on top of the company gives rise to adverse tax implication. Having discussed the various ownership options, being personal, being trusts, and being companies, I'm going to now hand over to Taruna so she can discuss the concept of a trust in South Africa. Before heading on over to Taruna, I'll just mention, given that there is a South African audience, that the trust legislation in Mauritius in particular is different from a South African point of view, in that there is detailed trust legislation. The trustees are those persons who are authorized by the Financial Services Commission to provide trust services, or a company holding a management license. And the effect of that is that a trust comes into existence as soon as the contract is concluded with the trustees, and there's no requirement to obtain the letters of authority as existing in South Africa. Taruna, over to you.
Thank you, Ian. So I was told that South Africans do not really need an introduction about trust. You very well understand what is a trust, but I'll still take some few minutes to explain to you what are the peculiarities of a Mauritian trust compared to that or what exists under the SA laws. So to all those who would be interested to buy in Mauritius any movable property, but also taking care of the succession planning, the trust is one of the most appropriate vehicles that you should know about. So I'm not too sure if you are aware of the legal existence, how trust came into legal existence it's one of the oldest type of vehicle which exists in the world, and it came into existence when women were not allowed to legally own assets. So when the men were going to war, there was a need to find another man who was legally entitled to be able to own property. That's where the whole trust concept came into picture, and the name trust. So like any kind of trust, you've got specific parties which are compulsory in the vehicle. The first one being the settler, that is the one who is going to give the first assets to the trust. And then you've got the trustee, which is the most important party of the vehicle itself. Like Ian has said, under the Mauritian laws, it's not any person can act as trustee. It needs to be a management company like Juristax, and the trustee are the ones legally representing the trust. So any document, any execution on behalf of a trust would be done through the trustee. And the duties of a trustee, which have been listed, are more or less the same that you've got in SA, that is need to ensure to administer the trust in the best interest of the beneficiaries. Next slide, please. So apart from the settlor trustee, you've got another party, which is the beneficiaries, that is the persons who are able to benefit from the trust assets. They can be named trustees, they can be trustees who are not yet named, but a class of beneficiaries as well, which can be who can be appointed whenever the trustees would want at a later stage. And then you've got a protector. There are certain categories of persons who do not like the fact that trustees are the legal owners of their assets in a trust, and would really like to have a certain way where they can make sure that the trustees would only act upon written instructions of a particular person, and that person is a protector. Like the name suggests, he's the one to ensure that the trustees are acting as per the trust deed and the trust act itself. So if we move to the next slide, you'll see that in Mauritius, we've got two ways to create a trust. The first one is a trust deed, that is a document which is signed by the person who is giving away the first trust assets, that is the settlor itself. Then there is a second way of creating a trust in Mauritius, is a document which is signed by the trustees saying that they recognize having been endowed the trust assets, and they are going to make sure to administer the trust for the benefit of the beneficiaries in the way the declaration of trust have provided for. One important element of information for you to know is that in Mauritius, trusts are not registered. That is, there is no registry, a government institution where we need to submit the application of incorporation of a trust. So it's a private vehicle. It's a vehicle which is created among the settlor trustees and beneficiaries, if any. And it's created the moment the document is signed and the first trust assets is given. There is no need to submit an application back to any authorities in Mauritius. So it's really very private. There is no way that someone can go to a registry to look at who are the persons behind the trust, who is the settlor, who is the trustees or beneficiaries. It's not possible in Mauritius to do that. So you will move to the next slide, where these are the information that will normally be in a trust deed or a declaration of trust. This is quite literally the name of the trustees, the persons who would act as beneficiaries, what property would be given to the trust, and the duration of the trust, in what way you want to distribute the trust assets to your beneficiaries. All this information can be included in the declaration of the trust or the trust deed. It can be really tailor-made and it's very flexible. So sometimes clients would tell us, I do not want my children to get any trust assets until and unless they are married, or until and unless they are 25 or plus, or the trust assets must be used only for the education of their children. It can be really specific to each family or to each person who is creating the trust. If we move to the next slide, we'll come to, I believe, what are the advantages of having a trust. Like I said, it provides a lot of flexibility and a lot of protection to the assets which are endowed to the trust. Confidentiality, because like I said, there is no other party who can have access to the trust documents, be it the trustee's resolution or the identity on the settlor and beneficiaries. There is a possibility for the settlor to give instructions to the trustee the way in which he wants for the trust to be managed. And if he's no longer there, he can write a letter of wishes telling the trustees after his demise how he wants the trust assets to be distributed. We can accumulate the trust vehicle with any kind of other type of licenses, which is the GBL, but it will really depend on what you really want the trust to do. Is it a kind of business or only holding assets? But because a trust can do both. It can also do business. We can use a trust for charitable, non-charitable purposes, doing business, or just asset holding as well. We'll move to the next slide, and it continues on the advantages of a trust. One very important thing is, which is very peculiar in our laws, is the anti-forced heirship rules. Now, what is it? Every time I explain it to a client, the client would normally smile, and I would say, this is the thing which really differs the Mauritian trust from other trusts. So for you to know is, if tomorrow a non-Mauritian, a non-citizen would come to Mauritius, create a trust, give away some assets, money or property, movable property to a trust, the endowment, the donation which has taken place cannot be attacked by his legal heirs, even if it's against the laws of succession of his domicile or tax residency. And this is incredible. Like, there is a number of persons who would normally be your legal heirs, but if you want to disinherit someone, you do not want to leave it to those persons, but to someone else. The Mauritian trust is a vehicle which would allow you to do it, which is not which is something which is very, very rare in the different type of laws on trust which exist around the world. So there is also the possibility of migrating a trust. You can create a trust in Mauritius today and tomorrow decide to take it somewhere else for it to be subject to laws other than that of Mauritius. It's possible to migrate it to somewhere else. The third one is the protection from creditors. So what is this advantage of protecting the assets of creditors? We move to the next slide. The trust, once someone has given the assets to a trust, he's no longer the legal owner of the trust. He does not have any legal ownership of that trust. It's the trustees representing the beneficiaries who become the legal owners of the trust. So if tomorrow there is any claim against the assets of a settler, there is a creditor claim, the trust assets which has already been given to the trust cannot be attacked on the basis that there is a claim, that there has been a judgment given against the settler. As the Trust Act, you'll see the exact article of the Trust Act, which is on the slide, which says clearly that the trust shall not be void by reason of a settler's bankruptcy or liquidation, or proceedings against the settler at the suit of his creditors. And this is why we say in Mauritius that the trust provides 100% protection of assets, be it against from creditors, or in the case of any judgment which is given in the event of a judicial separation. It's going to be the same thing. Unless the trust has been really created to defraud the creditors, then it's another thing, because there will be intent to defraud and it will be criminal. Then we can attack the trust assets. But in any other cases, we cannot attack the assets which has been given to a trust on the basis of a bankruptcy or a judgment somewhere given. I think the next slide would be on it. It's another article. Can you just, yeah. So it's another article in the Trust Act, which expressly provide how the Mauritian courts would not have jurisdiction or competence to declare, to recognize the validity of a judgment which has been given by another court, where the court has said that we need to go to attack the trust, the assets which have been already given to the trust. So I think all these advantages and about the anti-forced heirship rules, protection of assets, are the main features of a Mauritian trust, and which would normally attract persons who would come to Mauritius and decide to live here and to acquire property and make sure that that property stays in the family and go down the generation. I think with this, I come to an end to the part of it, what's a trust and what are the advantages having one under Mauritian laws. So thank you so much.
Thank you so much. And I know now's not the time for questions, but maybe a question to bank for later was, so if a property is put into a trust and let's just say you live in South Africa and you get divorced, does the partner that you're getting divorced have no access to the property in the trust if they're not a beneficiary? And similarly, could a judgment from the taxman in South Africa not have any effect on that trust either? Maybe questions for the end of our discussion. So we've looked at what we need to consider from a tax perspective. We've looked at what we need to, the options of how we wrap that purchase. Now let's look at accessing a bank account in Mauritius and financing property in Mauritius. Diana, if I could hand over to yourself and we could take that topic and break it down a little bit further.
Thank you, Louise. So when someone is willing to buy a property in Mauritius, normally he will either pay the property by means of cash, a bank transfer, or looking for a financing facility with a bank. So we are here to guide the customer from the start to finish of the acquisition project, that is till the delivery of the house. So I'll just give you a quick overview of who we are and what is ABC Banking. So ABC Banking forms part of ABC Group. The group itself exists since 90 years, and our main cluster, we've got 5, as you can see on the screen. It is automobile, financial and insurance services, food, shipping and logistics, and banking. So the ABC Banking is a young bank. Since 10 years. It has been incorporated in 2010. So initially we were giving leasing facilities. Then in 2010 we have got our banking license. And the bank has 4 main pillars. It is the private banking, the retail and corporate banking, international banking, and the treasury. So if we can move on the next slide, please. Yeah, so I will talk mainly on the private banking services. So the private banking team consists of 5, the head of private banking, 3 private bankers, and 1 support officer. So basically, as you can see, you have a personalized service. That is, you will have a relationship manager who will look after your accounts and guide you in your investment products. And also, you have lots of advantages and privileges as a private banking customer. That is, you can have a fast tracking, that is for your home loan files or other credit facilities. You have prime access to our products, for instance, the Diamond UPI card. You've got exclusive invitation to events. Normally, we organize events for our private banking customers like Porsche, etc. And also you have access to our investment products. So we work with collaboration with ABC Capital, which is our sister company. And if a client wants to have any guidance on investment products, so we will be happy to assist. But mainly in this session, we will talk about banking facilities, that is credit facilities when a client wants to take a loan to. So if you can move on next slide, please. Okay, so normally for a foreigner non-resident or foreigner resident, we can finance up to 60–70% of the acquisition project. That is the price of the property, excluding any costs that may relate to notary, agency, or land transfer. So let's say that the property costs 10 million rupees, so we can go up to 7 million as bank financing. And we do provide loans in MUR, that is Mauritian rupees, and also in different currencies like euros and USD. And we have also the expertise to deal with VEFA project, that is a project VEFA in future state of completion. And we do have expertise to deal with, for instance, a person who is willing to acquire a property through a trust. Also, just a quick note on the loan process. That is, as soon as we have a set of documents that we will request from the customer, the time frame will be 1 to 2 weeks. If an employee, that is, if the person is an employee, and if it is a self-employed, it may take 2 to 3 weeks. And just to mention that we have, it is not on the screen, but we have competitive rates in USD, dollars and rupees. And of course, it will also depend on the profile of the customer and other factors like, for instance, what is your percentage of contribution? For instance, if you want to have a deposit in a bank account, so of course we can review the interest rate. Next slide, please. Okay, so normally when the bank will intervene in an acquisition project, so the client will identify the property, approach the bank, will do a pre-assessment depending on his revenue and all. So we will deal also with a promoter to have all details about the price, when the delivery will be done, and as from that we can have an idea when we will start the loan process. And also we deal with other stakeholders like the valuers. Normally the clients need to liaise with the valuers, the insurance agents, the promoters, the notary. So from our part, the relationship manager can liaise to facilitate things for clients, especially for those who are not in the country. So we have a better communication here in Mauritius. So just to ease the clients. If you can just move to the next slide. We have got some criteria for the private banking for you to be able to fit in the private banking. So it will be either through a bank financing. So that is a credit facility, either in terms of home loan, term loan, personal loan. And to apply for a home loan, it is a minimum revenue of $5,000. And also, we have some procedures to open a bank account in Mauritius. Of course, you will need a bank account to transfer your money if ever you are coming to settle or have business here. Normally, we go through procedures. We will refer you to either international banking or corporate banking if ever you want to set up a business. But in some cases, on an exceptional basis, if you wish to invest in terms of investment products or have a deposit in a bank account, so we can consider without you going through all these procedures. So just one thing, if you can just go to the previous slide. Just one thing that we wish to mention, the disbursement is done in several parts. That is, we won't disburse the whole amount at a go. So it is one way for the bank to monitor the progress of the construction as well. So you may be sure that the project will be completed and that we won't disburse everything and you will have to worry, for instance. So the bank has a close follow-up on that. And when we will intervene, it is when the client has already injected the whole contribution in the project. That is, for instance, the notary will ask you, for instance, 30% at the signature of the deed, and it is upon this whole contribution that the bank can start disbursement. Next, please. So as I mentioned here, the minimum deposit is USD $100. That is around 84,000 rands if you wish to open a bank account. Of course, you can have transactions on the account, that is cash in and cash out, but you will need to maintain the account. For instance, a person cannot just open an account. He deposits money and after 1 week he withdraws all money just for the sake to have an account. So there is a minimum criteria to respect. And I'll be glad if you have any questions, so I'll be glad to answer. Thank you.
Thank you so much, Diana. So very interesting, the opportunities that come with an off-plan purchase. So what we're very excited about today is when we started doing the investigations around looking at a financially focused webinar and start talking about tax, off-plan purchases obviously was a big part of that. And the structure of an off-plan purchase in South Africa differs from the structure in Mauritius. Some of you might know that already, and those of us who don't, we're going to have a look at this a little bit further on. But in our investigations, we were so excited to be approached by a brand new development that is going to be built on the north of Mauritius. And we spoke about it in a dress rehearsal the other day. And as soon as we mentioned it, Ian, you know, his ears sort of popped up and he was like, oh, and he started to ask us a whole lot of questions around this purchase, around this property or this potential development. So before we look at this and we look at the off-plan purchases, let us give you an idea of what this development is going to look like. And we're going to play a short video which will showcase exactly what we're talking about. And I'm sure you'll find it as exciting as us. Julia, if you'd like to pop that video on, that would be super. Development is on the northern side of Mauritius. So please excuse my very rudimental math there. I think if anything has come out of COVID-19 is my PowerPoint skills. So it's on the northern coast. It shoulders Grand Gaube, and it's in an area called Grand Gaube, I think is how the correct pronunciation. Grand Gaube. I asked Olivia to record it for me, and I've been listening to it. And what is exciting about this project is the fact that this is traditionally known as quite an area that is quite flat in its topography, and this particular development is on a raised section of land, and that has enabled the properties to have phenomenal views, which is something I think that we're all very excited about. So let me hand over to Fabrice and to Olivia. Olivia is going to take the reins on this particular as we break down what the development is around, just for ease of information. But please, if you have any questions as she goes along, just pop it in the chat box. And Olivia, can I hand it over to you?
Yes, thanks, Louise. So yes, this is a very exciting project. North Island's view is, as you mentioned, on a hill in Grand Gaube, and for the South Africans who know Mauritius, you will know that the north coast is pretty flat. So it's quite challenging to get a view from any of the projects that you will buy into. Whereas North Island's view is in Grand Gaube, only 12 minutes away from Grand Gaube, only 15 minutes from international schools, 2 minutes away by foot to the nearest public beach, and it's actually on a hill. So all the apartments from the ground floor, you'll have a bit of views, but from the first floor and the penthouse, you will have the superb view that you are seeing now on your screen. So it's absolutely wonderful where it is positioned. It's very close to the 5-star Hotel Luxe Grand Gaube, And they are negotiating at the moment with Grand Gaube so that the owners of properties at North Islands View get a membership and can have access to that hotel. And they're also discussing with 2 other hotels. So people buying at North Islands View will be able to obviously live there and have a very Mauritian lifestyle, so enjoying the ocean and the beach. So as you've seen in the video, there are 35 units of top A-class buildings. So they have surrounded themselves with the best partners on the island, project managers, builders, and all of that. And because the promoters are French, they are really in line with all the French procedures, if you want. They really are very specific about that, which I like about the project as well. Now, as I say, 35 units, you have 5 penthouses. You will have 10 garden houses, like the one at the back of my screen. These are detached villas on ground +1 with 4 bedrooms, 4 bathrooms. It's 225 square meters, so perfect for a family. The penthouses are also 4-bedroom penthouses. Every room is en suite, so in the villas, in the apartments, and in the penthouses. And the apartments are 3 bedrooms, en suite, 170 square meters. And you're looking at starting investment of 7.1 million rand approximately. So quite affordable compared to all the other projects you can find on the island. And I think the fact that you've got a spectacular sea view, you are on the north coast of the island, make it a really wonderful project. Now, what I really like about this project as well is the fact that it's going to be a completely secured project. So it's a secured estate, or smallish estate if you want, with 2 large swimming pools. But what they've done is they really want South Africans to be the next owners of these properties. And they have actually organized an area, like a garden area, with a braais and a place where all the community can get together. So it's a very much with the South African concept. You know, I know that South Africans like their braai, and they really went the extra mile to keep a lot of garden space. We are looking at 11,000 square meters of land, and they are building on less than 40% of the whole amount. So that gives a lot of green areas and stuff to the owners. And then the other interesting parts, I think we're going to move to the next slide on obviously the payment schedule, which is what you spoke about, Louise.
Okay, so I think what is interesting, and it's a beautiful project. So there's a variety of property opportunities from your as you mentioned, your garden homes, right across the way to your penthouse apartments. This is an off-plan purchase. So I think what we noticed in our research is working with South African property developers and the structure of an off-plan purchase versus the structure of an off-plan purchase in Mauritius. And this is what's quite interesting. And I thought, let's break that down and have a look. The payments in Mauritius is referred to as a construction background cause. And these background, I heard pets are definitely something you can take to Mauritius as well, and we'll cover that on a different webinar.
And you can take your dog to Mauritius, as you can tell.
Yeah. And so let us have a look at how these construction background calls, or how these payments work. Julia, if you could pop onto the next slide and let us go through it. Olivia, if we could have a look, I've highlighted on the slide, we're using an example of an apartment that we could purchase from a North Islands View. It's a 170 square meter apartment. Its approximate value at the time of me putting the slide together was 1.7 million South African rands.
7.1.
So 7.1. I wish it was 1.7. So, sorry, guys. 7.1 million South African rands. And Olivia, if I can hand it over to you, if you could just go through that breakdown and how it would work from an off-plan purchase perspective.
Yeah. Thanks, Louise. So as Diana mentioned earlier, when you buy a property in Mauritius, it's very buyer protective. So we are in line with the French law, the French Code Civil. And so when you buy a property off plan, it's according to the VEFA law. So Diana spoke about it. In French, it's vente en l'état futur d'achèvement, which means that you will buy the property, but as soon as you sign the deed of sale, you become the owner of that property. And you pay in phases. So as the construction goes ahead, as the architect and the project manager sign off that yes, the property has reached a certain level, we'll send this through to the bank and they will then pay the percentage. So here we've done a case study for you. So based on the entry-level apartment of 170 square meters, 3-bedroom ensuite with wonderful sea views, it's 7.1 million rand. And what's great about North Island's View is that at the signature of the reservation contract, you only pay 5%. Now, bear in mind that 5% doesn't go into the promoter's account, it goes into the escrow account of the notary. So it's very safe, again, very buyer protective. So 5% will amount to 355,000 Rand. So this is paid at the signature of the reservation contract. And then it will take about, because bear in mind, this is a new project off plan, there are only 35 units. We believe it will take about 4 to 6 months to reach the certain level that we need, which is 70%, to be able to get the bank guarantee to start the project. So as soon as we get that bank guarantee, we will get the PDS certificate from the Economic Development Board, and then we can start signing the deed of sales. What's interesting is at the signature of the deed of sale, this is where we can start, well, the promoter can start to apply for your permanent residence permit, or Juristax can start applying for your permanent residence permit. So you will become a resident of Mauritius even before your property is delivered. So at the signature of the notarial deed of sale, you will pay 25%, which amounts to 1,775,000 Rand. At that time as well, you will have to pay the 5% government tax, so the land transfer tax. And the notary fees, you will see it's written offer next to it. It's because the promoter will take on the notary fees they will pay for it for the first 10 units that get reserved. So if you are interested in this project, I really encourage you to contact Fabrice and start getting the ball rolling, because the first 10 units will have the notary fees for free. So it amounts generally about 233,000 Rand. So that's quite a nice discount. And then from there, we will be able to start the construction of the project. And at the completion of the foundations, this will be guaranteed by the project manager and the architect. The foundations are completed, and that's when you are asked as a purchaser to pay another 5%. And then it goes in stages. So then after a few months, when the completion of the roofing, so out of water, it's called hors d'eau in French, you are asked for another 35%. And then at the completion of the building works, 25%. So that will amount to 95%. Then you will see your property, you'll be able to go around, and as soon as everything is good for you, you are happy with the property, you pay the last 5%. So that's how it works. So it's very much buyer protective. And bear in mind that as soon as you become the owner of the property, as soon as you sign a deed of sale, you can actually resell. So for the investors who are listening to this webinar right now and after, this can be an opportunity to buy the property at the starting price and resell it when it's being built. So I think I've covered the whole thing now.
Okay, great. So just Olivia, the structure that we're discussing here, although the percentages might vary, is the structure common throughout all off-plan developments across Mauritius? You will always pay it in these segments at the specific rolling out times?
Yes, so that's a good question. It is, according to that VEFA law, It has to be in stages, and there are certain percentage that you have to respect. Now, what's great about North Island's view is that at the signature of the reservation contract, you only pay 5%. Whereas with some other promoters, you might be talking about 10 or even 15%, which goes into the escrow account of the notary. So that's where I find that North Island's view is great, because it's only 5%, and then you pay the remaining 25% at the signature of the deed of sale when the construction is going to start. Bearing in mind that according to the law, you need to pay that 30% at the signature of the deed of sale. So all the deposit that you pay has to amount to 30%. So that's why some promoters play with it and have like 15% at the reservation contract, others it's 10%. But with North Island's view, it's only 5%.
Okay, and you mentioned, so just to recap there, at what point in this process can you put the application in for your residence permit?
At the signature of the deed of sale. So when you go for the signature of the notarial deed of sale, we can immediately, the promoter can immediately start the procedure. As soon as you give through all the documents, all the necessary documents, they can action the permanent residence permit. And it will be in the name of the buyer, or if the buyer, for example, is buying it for his children, it can be in the name of the children as well.
Okay, that actually is a question that came up, and maybe I can take this question to, I actually got a couple of questions just to the panel. One of the questions that I received this morning was, if I am purchasing a property, can I purchase the property in more than one party's name? Can I maybe ask that question to Olivia?
Yeah, so basically, if it's a married couple, it can be in both of their names. If it's through a company, it can be in the name of the company. However, the permanent residence permit will be for only one of the directors. So they will have to say it's this director who will get the residence permit. So to answer your question, each property allows one residence permit for the buyer and his spouse and children up to 24 years old. So I think, does that make sense?
So sorry, just to...
Yeah, just maybe correct.
Thank you.
I maybe correct. It's not in the name of the director, but in the name of the shareholders, effectively, the person will benefit from it. Because invariably you won't have the South Africans as being the directors of that company because of the tax implications. So it's the promoters, or the owners.
Sorry, my bad. Yeah, I meant owner or shareholder. Sorry.
So Ian, can I just take that a step further? So if I'm a more than one person, not necessarily married, that buy a property together, do you then that residence permit is it for both individuals that are buying that property? And
in the case of a married couple, as Olivia pointed out, it's husband, wife, and children under the age of 24. In the case of ownership by a company, it will be the family members of the owner, for lack of a better word. In the case of the trust, it will be the beneficiaries of that trust as well, but limited to a family unit. So where you end up with sort of unmarried parties buying the property, as far as I recall, the residence permit will only be issued to one of those parties, and in the case of same-sex buyers, only one of them.
So one of those parties and their family.
Correct.
Okay, and how would it then work for a life partner, where they're not married but they're a life partner?
I'm going to decline to answer that.
Okay, we'll have to do further research around that, which is something that's important. I think the structure of the family unit is very dynamic nowadays.
Yes.
So very exciting, very exciting product, and thank you so much, Fabrice and Olivia, for presenting it. I just want to take us a little bit back to a couple of things. So, from a bank perspective, Diane, if we are financing this off-plan purchase, so as a South African, I come and view the property. I come view actually the State Living website. I decide that I want to invest in a property off plan. I have the cash flow, South African rands, to put down the 355,000, and I'm able to open up a Mauritian bank account. But at that point, do I now apply for financing?
Thank you for the question, Louise. So what we advise customer is that we have a pre-assessment, because normally this type of project, it lasts over 18 months to 24 months. So we have a validity period of 3 months. So if ever a client is applying for a loan, definitely he will have to revalidate the loan, and at a point of time we have to start a fresh request. So what we do, we send the client a list of documents. So we will have a pre-assessment based on his revenue and for instance salary, dividend and other income. So we will tell the client that we are comfortable to proceed with the request, but he will have to wait, and maybe we can liaise with a promoter to see when the first disbursement is expected, and from there we can plan to start the loan application. And of course we need to note that for foreigners the bank is willing to work via distance. So we can start the application if ever the client is in SA, so he's not in Mauritius, we work via distance. And if ever signature is to be done, it's not necessarily at the bank. We can do it in front of a notary or commission of oath in South Africa. So we give that flexibility to clients. But for the loan application, it has to be some month before the first disbursement.
And then are you then paying, so once you've got your loan application and that first disbursement has gone through of 25% or whatever that value is required, are you then immediately now paying costs around that 25% that has been dispersed?
When you're saying 25%, it is the first 25% at the notary.
Yes,
okay,
that's correct.
So the bank will ensure that the project has been paid 25%. That is, the client has paid his part of contribution, 25 or 30%. And as from that, we will have a site visit on the location to see, of course, if the completion stage has reached 25% or 30%. As from that, we start disbursing. Let's take an example. So if we are talking about 10 million, the first disbursement is 2 million. So we disburse the first 2 million. And when we will have a call of fund from the promoter, so when we will have a call of fund from the promoter, then we will have another site visit or maybe a progress report from the promoter himself, to ensure that the bank, the money that we have disbursed, that is the 2 million, the cash has been put in the project. So this is why it is in several phases, like Olivia just told. Yeah.
Okay, thank you. Just a quick, I know we're running out of time, just a quick question to Tahura. So we've now got an opportunity to make this purchase, and the decision comes of whether to purchase the unit and put it into a trust. I can understand some of the benefits of creating a trust if you want to protect your assets or you want your family. But maybe in this case, I've decided to purchase this unit because ultimately in the next 24 months, I plan on emigrating across to Mauritius. What would you recommend that this property then is placed in a trust, or at what point would JuryStax recommend a trust as an option for a property purchase? Is it...
In fact, the trust, we can create it prior the signature of any document for the acquisition of the property itself. The trust is like a suitcase. It's where you put all the assets you want it to hold in the end for you to be able to pass it to your next generation. So you don't need to wait for any kind of acquisition or investment to have it created. It's better for you to create the trust first, and you can create the trust with 100 rupees, just having the trust deed signed by the person who wants to act as settler and who are the beneficiaries. You can just give away 1 rupee if you want, just to make sure that it's legally in existence. And then afterwards, whenever you've decided on what type of apartment, villa or penthouse you want to buy, then you can ensure that the notarial documents would be on the name of a trust itself, which is represented by the trustees, instead of having a person, a physical person, getting involved the name on the papers. You can have a trust name already there at the moment of the acquisition.
Do you need to have your residency permit in place before you can create the trust?
No.
And
in fact, the trust can be created by anyone. There is no need for you to be a Mauritian citizen or Mauritian resident. You don't need to be here for the creation of a trust as well.
And can that trust benefit anyone? You don't need to be a Mauritian citizen.
Yeah, of course, same thing.
And if you are deciding to form the trust, and I think this was earlier question, if you have a judgment against you in South Africa, a tax, say from the South African Revenue Service or something like that, can your assets within the trust be tied in any way to that judgment? I know you said earlier it couldn't, but I think there's a difference between Joe Soap and the South African Revenue Service. Ian, maybe you can.
Yeah, I answer part of it, Louise, and then Ian can just join in on that. Like I said, the Trust Act is very specific. The Mauritian Trust Act, the way it has been drafted, it has incorporated expressly, I've provided in the slides, the way in which any foreign judgment which is given against an asset which is already settled in a trust cannot be attacked, even if a settlor has been found to be guilty or there is any kind of claim against him in SA. However, as of now, there has not been any case. There is no jurisprudence where this has happened and there has been indeed a foreign judgment given against a trust asset. So there is a law, but the application of this law, we have not yet experienced any of it. But if we need to go literally by what is written in the Trust Act, so it's not possible to give effect to these types of judgments. Unless, like I said, there has been an intent to defraud the creditors. So the trust was created at the beginning itself with the idea of not paying the creditors. And with this criminal intent, then the Mauritian courts can give effect to that judgment. So Ian, you can just add on that if you want.
I'm just going to add here, SARS has no locus standi in Mauritius. To the extent they want to execute an order in Mauritius, come to the Mauritian courts and get the Mauritian courts to issue an order. The Mauritian courts are not going to issue an order.
I think just also we're running out a little bit of time. I just want to wrap up. I've had a number of questions come in regarding the minimum payments required if you want to access a permanent residency through immovable properties. So there are two amounts that are kind of floating around. One is the 375,000 USD, and the other one is the 500,000 USD. Perhaps Anna, who is the best person to clarify this for me? Tahura, maybe yourself, if you could just, if you're wanting a permanent residency for yourself and your family, and you're doing this through a property purchase, what is the minimum payment requirement?
I think you asked to me, right, the question. So to get the permit itself, so it needs to be around $375,000, the value of the property. But like Olivia has said, there is no need for the property to be there physically already built in for you to get the permit. At the moment, you are dispersing part, I think 25% of the payment has been made. And no, it's not 25, sorry. At the moment, the deed of sale has been signed. The notary, once the notary has executed the document, this can be submitted for you to get the permit. So you don't need to disperse the whole amount, but at the moment of the signature of a deed of sale, the value of your property should be at least $375,000 for you to get the residence permit, which is indeed the permanent residency permit. As long as you would have a property in your name, you would be entitled to live and have a residency permit with your dependents, including your spouse, legally married, or your common law partner. I think you had a question about it early on. So the law, Mauritian laws does recognize non-married couple, but who are considered as common law partners, that there is a pact. There is a certificate of what we call here an acte de concubinage, which can justify the relationship and substantiate it. So this is recognized as well.
Yeah, perfect. I just have a question coming in here. I'm just trying to wait for that question to come in. So there is another amount of 500,000. I've seen it floating around. Is it a different type of development where they refer to it as +2?
In fact, Louise, the $500,000 was the amount that initially was required for you to get the permit. And this has changed. Now this has been reduced to $375,000. In fact, the 500 was the earlier amount.
If I can add to that, I think maybe someone has got the answer, but I think if you're buying a ground +2, it has to be an amount of $500,000 in order to get the residence permit. But through a PDS, it has now been reduced to $375,000 to have that permanent residence permit. I think that's what I understood.
Yes, thank you. So I just have one last question. I know we're running out of time quickly, and this just comes from one of our attendees. It's a question from a Mauritian perspective. The question is, if you have 2 Mauritian parents, do you qualify for citizenship or only for a passport? Who's best to answer that for me?
That's easy, Louise. It's both. If she has 2 Mauritian parents, she must just apply to get a passport, and then if she gets a passport, she becomes a citizen. A permanent residence permit doesn't give you a passport to Mauritius. It gives you, it allows you to live in Mauritius all the time and bring in your family. Well, your spouse and your kids, but it doesn't give you citizenship. A permanent residence permit doesn't give you citizenship. But if you've got Mauritian parents, you can apply for citizenship and you'll get the passport.
Great. Sorry, there was just I see Ian is the our keyboard warrior on the side there. All right. Well, thank you so much to everybody that's participated. Thanks for you that have stayed with us for this little bit of extra time. Thank you so much for Brice for launching this exciting new development with us today, and for everybody for giving your time. There's been a few questions that have come up in the polls. One of them that's coming up now is just please feel free to answer the polls. We'll give you all the feedback. As I've said, we will be recording this session. We will have it recorded with the playback, with the Q&A coming in on the side. And and thank you again to everyone. And I hope everybody has a lovely afternoon. And I will enjoy the rest of the day at the beach behind me. And thank you again for everyone who's participated.